co-chair is my friend Elliot Prescott from the Appellate Court, Judge Elliot Prescott. This is a public meeting, as you all are aware, and it's being in real time broadcast, if that's the right term, on our YouTube channel, the branch's YouTube channel. If anybody is watching from the public, we welcome you to the meeting. It's this is a great improvement that we've been able to advance so that folks can, if they're interested, monitor the meetings, tune in for what they might be interested in. You bear with me and my co-chair here. This is an august group that we're chairing, and so that, in addition to the fact that I haven't had this many people on my screen yet, so managing and making sure that everybody's heard from, please just bear with us. I'm sure you all will be patient. We're going to try to use the raised hand feature. There's an icon. For me, it's up at the top of my screen. Sometimes it's been at the bottom of my screen, quite candidly. And so I will attempt, or Judge Prescott will attempt, depending on the topic, to see who's in the queue and recognize you as you've raised your hands. If you could identify yourself when speaking, if we haven't just called on you to recognize you, including for purposes of Colleen taking the minutes, including if you're making a motion or you're seconding a motion. If a number of people go at the same time, we'll try to sort that out. Or if Colleen, you have any questions about that, pipe in when it's appropriate. If you all could keep your mics muted too when you're not speaking, the background noise, shuffling of papers, noise can kind of overtake the conversation oftentimes. So if you could do that, we'd appreciate it. And so I think rather than, usually when we're in a room like this, we'll try to go around the room, but I think for purposes of this meeting, I will actually, sort of in the form of taking attendance, let me go through who I think is on this meeting, and you let me know if you're here, or we'll figure out if somebody is not here. Jeff Babin from Wigan and Dana.
Yes, I'm here.
Thanks, Jeff. And Colleen, we've heard from already. She's from the Appellate Court. And that's Colleen Barnett. Jill Begeman is the Chief Administrative Officer. What is the title we use for you?
Right now, Director of Appellate Operations.
Director of Appellate Operations.
Right.
Yes.
And I'm here.
Kathy Calaby from Riscassi.
I'm here.
Is Rich Emanuel on? I see an RE. That might be somebody else.
He's here, but he's muted. You're on.
Okay. Thanks, Dan. Rich Emanuel, sounds like he's on. Is Paul here? Paul Harton?
Yes, I'm here.
And Ken Barchi is going to be here in place of Wes Horton. Ken, have you made it? Maybe Jill, can you shoot him a message or, great. Claire Kindle from the Attorney General's office.
I'm here.
Great. Dan Krish from Halloran.
Here, Your Honor.
Eric Levine from the Reporter's office.
Here, Your Honor.
Bruce Lockwood from the Chief State's Attorney's office.
Here, Your Honor.
Jesse Opinion from the Staff Attorney's office.
Here, Your Honor.
Jamie Porter from the Appellate Court.
Here, Your Honor.
Charlie Ray from McCarter.
I am here, Your Honor.
And Lauren Weisfeld from the PD. I see you, and I think you're muted, but you're waving. Yes. Giovanna Weller from Harmony.
Here, Your Honor.
And Carol Anziogas from the clerk's office.
Here, Your Honor.
And is Renee on? Renee Robertson from the clerk's office?
I'm here, Your Honor.
Great. And is there anybody else that I haven't mentioned? Let me, as I mentioned, Ken Barchi should be coming on because he has an item that Wes's item that he's going to speak to. So I hope we'll hear from him. I want to welcome Jesse Opinion, who after years of service to the committee by John DeMeo, staff attorney, Jesse has been appointed by the Chief Justice and she's joining us. So welcome to Jesse. And this is Kathy Calaby's last meeting. As some of you may know, she is retiring at the end of the year. And Kathy, I'm not going to embarrass you much, but this is a circle of friends that you've, in many forms you've seen and, socialized with and had meetings with over the years. We're going to miss you terribly. Your wise counsel. I've had the great pleasure of knowing her husband and her son as well. And yes, and Kathy, you can tell Henry I said it was a great pleasure. So Kathy, we recognize the fact that you've contributed a great deal to this committee and appreciate your service and wish you well in your retirement.
Thank you so much. I appreciate it. I've enjoyed being on the committee and will miss everybody.
Judge Prescott and I are going to alternate sort of every other item, kind of chairing the discussion. I'd ask, I am very protective of people's time. I try to, without not discussing things thoroughly, but folks contribute their time to this committee, and so we'll try to move things along. And I say that for the members of the public too that may be watching. So if things are headed somewhere where it's going to take more study, we may want to move the conversation along and think about that. Jill or Paul can interject whenever we go off course, Judge Prescott and I. But we're going to take one agenda item out of order, which will be clear in a moment because Renee is here to speak to it. If you're speaking to something particularly, anybody that's contributing, and it hasn't been done, or you're the first one to comment on it, if there is somewhere in the packet that has been distributed that you can identify and let people know where you're speaking to. When we're all around a table, we all cheat off of one another and say, where is that? And, what are we talking about right now? And we're not really able to do that here. So if we can let people know where we are, that would be appreciated. So before I go through the agenda items, Judge Prescott, anything you want to add?
No, I think that covers it.
Jill or Paul, anything?
No, I think you've got it. And Jill has her hand up.
I do. I just heard back from Ken Barchi, and he says he's having technical difficulties and hopes to be on soon.
Okay.
So.
Very good. All right. Well, then the first thing in order would be you have the minutes from the last meeting, which Judge Prescott and I were not at, but if you've had an opportunity to review those, and if there's a motion, we can entertain it now for approval.
So moved.
Attorney Kendall moves.
I second.
Attorney Krish has a second. Any discussion? If not, all those in favor, say aye.
Aye.
Aye. Aye.
Any opposed? Anyone opposed? All right, that motion carries. We're going to take what was on your agenda as item D concerning transcripts. We're going to take that first. And either Carolyn or Renee, if you want to lead out that discussion, we can take it from there.
So Carolyn, I'll ask you to start off because you were at the last meeting and what some of the specific concerns were, and then I can follow up with the changes that we made, if you don't mind.
Yes, we had a rather lengthy discussion in this area. We had anticipated some more recent changes with the ordering of the transcripts. But as it turns out, they're actually not quite as far along as we had anticipated. So what we were trying to do is get the wording of the rules set so when their changes came place, we would be ready for them. During this discussion, some of the concerns, or the major concern, was using the same term, acknowledgement and confirmation, and that was unclear, and that the timing probably wouldn't be affected as quickly as we thought. So we went back to the drawing board and made those changes. And Renee also met with various people to discuss it further, that it was okay with those changes as well. Okay, Renee?
Yes, thank you. So I looked at the rules as we had proposed them last time with the word acknowledgement, and I understood the concerns that it was creating, because as the process works right now, acknowledgement has a specific meaning in that it's the portion of the transcript order where the official reporter has signed off on it and provided the ordering party with an estimated date of delivery. So I went through, and actually ends up working out a lot cleaner if we continue to use the terms that are in the rule now and just rework it in order to fit the new process. So this is the electronic ordering process that will be available. As of right now, they're still planning on having it available July of 2021. So the proposal, I assume you all have the proposal in front of you. This is, I think, my first meeting. So we went through and I changed, so acknowledgement will continue to mean acknowledgement, meaning that you've been provided with an estimated date of delivery for the transcripts. And your final document will still be a certificate of completion, or a completion of the order that provides with the final date of that the transcripts were actually delivered. And then what we did was we just switched what we're calling it at the very beginning of the process. So when you go online and you make your transcript order, you're essentially going to get just an order confirmation that's going to include the same information that's currently provided in the section 1 of the JDES 38 transcript order form, where it's, the name of the case, the trial court docket number, the dates that you're ordering, the ordering party, all of that information. So you're essentially going to, once you've completed the order, be able to just print off a confirmation that includes all that information. So that is where we reworked the process and how it's worded in 63-8, and then we updated 63-4 to match that order confirmation language. Did anybody have any questions on what they've been able to review?
And I think this is just a story again. So we're looking, I think, at pages 11 and 12 of the packet. Is that right? Carolyn, maybe you have that. I'm not sure Renee does.
Yeah, I do not have the packet. This is Renee. I do not have the packet. I just printed out my rule proposals to have with me.
Or maybe Jill. I'm looking at it. Jill, I think it's 11.
Yeah, 10, 11, yeah, 10, 11, and 12. This is Paul Houghton.
Okay. And so I don't see any raised hands. Does anybody want to discuss this further, or is there a motion? Does it require a motion?
It does. So I'll make a motion to approve the rule as drafted.
It looks like Jeff Babin has his hand raised.
Okay. Oh, I see it down there. Sorry about that. Go ahead, Jeff.
Sure. Well, actually, I just want to also mention, because pages 8 and 9 address the same issue with 63 or page 8 addresses for 63-4 and carries into it what was going to be on 63-8. And I just wanted to mention, because I had been kind of the person talking at the last meeting about my concerns, and I just wanted to mention that I think this actually resolves all of the concerns that were brought up in the last meeting in terms of the right terminology and what has to be filed within 10 days of the appeal with the 63-4 papers. This is doable. So thank you.
Okay, so we have a motion from Attorney Harden to amend, I guess it's 63-4 and 63-8 as in your packet. Is that the extent of it?
No, there's more. It's also, this is Jill Bagaman. It's also 66-6 and 77-1.
Oh, gotcha. Yep. Keep scrolling down. Yep.
All related changes.
Is there a second?
I'll second. Kathy Calabi.
Kathy Calabi. Any further discussion? If not, all those in favor say aye.
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 Any opposed? Okay, that motion carries.
Is Ken Barchi on now?
I see a KB. Is that somebody different?
Looks like he's on.
Okay. Ken, if you can hear us, you must be muted, which is great. But we're trying to use the raised hand feature. And that's the icon up at the top. And we'll be turning to you shortly for the item you're here to talk
sorry I
about.
was late. We were having technical. Today was the day that the internet crapped out at our house, so I had to find alternate means.
Understood. We all need to have 18-year-old kids in the house at all times to handle this. That's the only way we'll get through the pandemic. So letter C, I'm sorry, it actually would have been B, about subsequent returns for the same filing. Carolyn, is this something you were going to talk about?
Yes, I am. So this is on page 5, yes. And this rule was also was on the agenda for last time. And we had a discussion about it. And I think it was Jeff had asked us to look at perhaps including some language from 66-3 regarding the statement when something is late. We did take a look at it, and we actually thought that it would be a little bit more confusing and too much guidance in the rule, because this rule itself, 62-7, doesn't just apply to motions, whereas 66-3 does. So that would require us to have additional information of guidance for filing motions for permission to file something late. And I when I was rereading the minutes as well, I realized we probably didn't bring this up, which might have been helpful, is that when this regarding the 15 days began in 2014, shortly after, we brought some concerns to the courts to get a policy regarding whether or not this should just apply to timely or non-timely and so forth. And so as a result of our bringing this to the court's attention, the policy was that they should be timely filed, and that there shouldn't be subsequent returns. It should be one shot, because they were having a lot of cases, particularly with foreclosures, where this was coming back and forth. So this is really something that's been in place. It's not something that's changed since about 2014, 2015. And we actually have the information, Jeff, if this would make you feel a little better, at the bottom of all of our returns, which of course you would know about it because I'm sure you don't have any of the returns. So, but we do have the language there. So what I would suggest, perhaps not putting it in the rule, but maybe adding some additional language to the bottom of our returns regarding the possibility of filing a motion for permission, and incorporate that language into 66-3 as well. So when the work group met, we decided that as a group that it was best to keep it as it is, because it has been working fine, and it's just making it a little clearer for the practitioners to know, have the wording in there that we're actually using now.
Okay. Anybody want to be heard on that?
Looks like Renee's hands up.
Yeah, Renee wants to know if she can leave.
Yes. Yes.
I just didn't want to hang up without knowing for sure that nobody had any more questions for me.
I think we're all set.
All right. Thanks, everyone. Have a good day.
So any other discussions on Carolyn's agenda item? Does this need a motion?
Yes.
I'll make a motion to approve the changes to 62-7.
I'll second it.
Any further discussion? All those in favor? Say aye.
Aye. Aye.
Any opposed? Anyone? Okay, that carries. Thanks. Judge Prescott, you want to take the next item?
Yeah, so we'll turn to item number C, which as I understand it was the subject of some fairly extensive discussion at the previous meeting. And this has to do with the appellate court's decision in Wachovia Mortgage versus Tozic. Jill has kind of a more extensive background and understanding of the history of this proposal. So if I can kind of lean on her to kind of maybe give a quick summary of how we got here, and then we can kind of turn to what to do next.
Okay. Briefly, last year the work group submitted a proposed amendment to 6114. And that proposal stated that any stay that was in effect during the pendency of a motion for review would continue until the time for filing a motion for reconsideration under 71.5 had expired. The proposed rule also stated that if a timely motion for reconsideration was filed, the stay would continue until 20 days after its disposition, and if granted, until the appeal was finally determined. The work group presented that proposal with the intent that it codify the holding in Wachovia Mortgage versus Tozic that said that the language in 71.6 concerning the continuation of a stay until the time for reconsideration had passed applies to stay under 6114. So then that was on the agenda in May. At the meeting in May, Wes Horton, if people recall, expressed the view that Tozic was wrongly decided. And he proposed a rule essentially indicating that a motion for reconsideration under 71.5 does not continue the stay unless the appellate court decides otherwise. And so then I asked Wes Horton if he would submit a proposed amendment, basically in writing, expressing the view that he had expressed at the meeting. So that is the work that is the proposal, the new proposal. In everybody's packets on page 6 is the new proposal. On page 7 is the original proposal. And before, I guess, we talked about the new proposal, the work group has looked at it. There have been not extensive, but there have been some meetings on that, some discussion on that. And, at this point, from the perspective of the work group, and I will defer to other members of the work group who want to, participate, or chime in. The idea is that the work group is not inclined to go with either proposal at this time. There was a general concern with the new proposal that which essentially overrules Wachovia Mortgage, that Wachovia Mortgage was following a Supreme Court case, RAL management. So it would be essentially overruling that. And there was also a concern among members of the work group that it could lead to, and it seems likely to lead to, an increase in motions practice, motions for stay. So it would potentially increase by adding another step and the workload on the motions practice. So that is by way of background and where the work group stands right now.
All right. Thank you, Jill. Ken, I know you're standing in for Wes, and Wes kind of led this out at the last meeting, but do you want to weigh in at this point?
Sure, and I would note that this is not the first time that he sent me in his stead when he had a proposal to present. So, Yeah, so he and I talked about this. I think in terms of the policy piece of it, I think that his concern is that it tends to be abused particularly he was thinking mortgage foreclosure cases, but I also do family cases, and I think there's a potential there for abuse as well. And so, once there's been a motion for review decided by the appellate court or Supreme Court, if that's where the case is, that seems like that ought to be enough review, because typically the orders that come out, if the stay is terminated, motion for review is granted, relief is denied, and there's no reason given or anything. So it's hard to latch on to some reasoning that might have been errant in order to justify a motion for reconsideration. So I think that was his concern in terms of maybe putting an end to some of this, some of this extended stay business. Jill had mentioned RAL management in the working group, thinking that might somehow be overruled. I'm not really sure that that's the case, because as I understand RAL management, it simply stands for the proposition that while there's a stay pending, any action to terminate, to execute on the stay is void. So if the court sets new law days, for instance, in a mortgage foreclosure while a stay is in place, they're void. But that doesn't necessarily reflect on when the stay ends. So if the stay is terminated, I'm getting some technical detail. So if the stay is terminated when the motion for review is decided, then I think at that point, from that point on, there can be proceedings to carry out the judgment. So as to increased motion practice, I guess if there is a real concern about trying to continue the stay, that could happen regardless of whether the motion for reconsideration or the stay is extended through that, because you could just file a motion under 60-2 and 60-3 if there was some reason, some good faith basis to do so. So I'm not sure what the concern is there, although I can see where there might be some more motion practice. So I think that's generally what he was thinking in terms of the policy reason behind it. But I think mainly what he was concerned about was that whatever the rule is, it ought to be clear. So which to my mind means it's either one or the other, but some way making it clear when the stay actually ends.
All right, I see that somebody has their hand up. That is.
It was me, Your Honor. Dan Krish.
Okay, Dan, go ahead.
I'm just curious about the last clause in Wes's proposed addition. Unless the court having appellate jurisdiction rules otherwise, I understand, I guess, why that's there, but is it anticipated that the court would do it sua sponte in some extraordinary case? When it denies the motion for review, it will on its own say that, or otherwise I just don't know in practical terms, when is that going to happen, as opposed to you having to ask the appellate court having jurisdiction to make this a special case, in which case I understand the working group's concerns about increased motion practice.
Ken, do you want to respond to that?
Ken, you're muted.
You're muted, Ken.
I'm not sure what he was what he was thinking precisely there, other than maybe the court keeping its options open, or I suppose you could request in your motion for review that the stay continue through the period of a motion for reconsideration, if there's some basis to ask for that.
Yeah, so the way I read that was that it would contemplate either as you just said, Ken, the party who's filed the motion to review asking that the stay continue through the reconsideration period, or typically this would be the appellate court would, in its order, denying, granting the motion for review, but denying the relief would indicate that, that, you know, if it thought the stay should continue.
Yeah.
Do other people want to be heard on this?
Judge Prescott, this is Paul Harton. I'm just, Kevin, I guess when the work group was talking about this, I guess the way I was at least playing this out was that if there is no stay, there's going to be, in many of these cases, there'll be a motion for stay, it seems to me. And then if the appellate court denied that, is there a motion for review stemming from that denial of the stay? So I guess I'm just trying to figure out, does the proposal accomplish what West is trying to accomplish? Or does it still, you know, allow for an avenue for the stay, at least on some level, to continue through motions?
Well, I think, Paul, that the way it would work is if the motion for review from the termination of stay is denied, or relief is denied, if the party then wants to seek a discretionary stay, I suppose they could do so, but the stay would not be in place until a court granted it. So there may be some increase, I suppose, in that circumstance, but I'm not sure why that couldn't happen under the current proposal, in that, you know, if assume that there's a denial of the motion for reconsideration, then I suppose the party still has an option to seek a discretionary stay. So I'm not sure if it's not happening now. I'm not sure why it would happen just because there's a inability to keep the stay going through the motion for reconsideration period.
Okay, thanks.
Claire?
Thank you. I am completely in agreement with Ken that we need clarity as to when a stay is in and out. And I'd be interested in knowing the working group. Carolyn has sort of reported that the working group now doesn't like either proposal. And I guess I would say that the original proposal was to codify the decision in Wachovia, and the counter proposal is to completely overturn it. I'm more for codification. Just keep the stay through, keep it clean, and make it clear when the stay, how long the stay lasts, and then just be done with it, as opposed to opening up in a whole level of motions practice. Typically in the state, we're pretty good about the stays. You know, we don't have a lot of motions practice on stays because they're of the rules. And I would, I would weigh in on saying, let's have clarity and let's simply have it through that point of motion for reconsideration, in and done. And then when it's actually finally done, you know that the stay is lifted.
Yeah, let me just respond to that for a minute, Claire. So as I see this meeting today, we have essentially three options. One is to adopt the proposal that Wes has come up with in some form. Two is to go back to the proposal which would codify TOSIC, or three, do not change the rule at all. So I think when we get to disposing of this matter, I think those are going to be the three things that are before us. And I agree with you, Claire, that this is a kind of an arcane area even for us, really, never mind the average practitioner. And I certainly think that there are going to be many people who are unaware of TOSIC, and that the proposal may alert them to its applicability. So I'm kind of in favor of that. Jamie, do you want to be heard?
Yes. When we talked about the change that Wes had proposed, I think the concern that came up mostly was that right now we don't get a lot of motions. If we have a timely motion for review, it's the motion itself stays the termination of a stay. And then if we have a timely motion to reconsider under the rules, that stay stays in effect. So we're not getting motions for stay in that interim phase. And what we were trying to avoid was having more motions come in after the motion for review had been decided, saying I need an extra stay. because we have some people who will file a lot of those, and particularly in the areas that Ken was talking about in foreclosure and family. And it's a 20-day stay there. I think what was more controversial was the 20 days after disposition of the motion for reconsideration. But that was the concern for an increase in motions practice because, you know, it can be difficult to get those handled quickly, depending on the time of year and what we have for COVID or non-COVID.
Jill, you're muted. There we go. Jill?
Yes, I'm here.
Did you raise your hand?
I did not.
Oh, that's what it's showing on my screen.
I think it's Jeff Babin.
Oh, Jeff Babin, sorry. Too many JPs.
We have too many JBs. I'm sorry, I can't put a middle initial. I don't know if that would help you.
Go ahead, Jeff.
Thank you. You know, I'm a little torn here because I in a way I agree with Wes's and by vicarious liability Ken's sentiments. I'm assuming Ken agrees with Wes. That these are provisions that were adopted in the Wachovia v. Thompson case that really address merits decisions, that this rule makes more sense to kind of let a stay in effect after a merits decision. And if the appellate court has issued a decision after reconsideration, having a period of time because there could be a petition for certification, for example, that sort of breeziness doesn't quite apply, I think, to kind of this motions practice, particularly where at least my understanding is that once it's done in the appellate court, for example, I don't think, unless there's some kind of a motion for transfer that's filed with a motion for reconsideration, there's really no recourse in the Supreme Court. So in a way, that extra 20 days at the very end is somewhat problematic in this context where somebody is focused on needing to terminate the stay. Every court has agreed that the stay should be terminated, and there's a sort of extra 20 days at the end that really doesn't serve any purpose. That said, I understand that, you know, there could be a lot of just extra motions practice for those who are for those who like to file motions. And so it's worth having some certainty. And if I would not favor having no change at all because I'm not, off the top of my head, I'm not familiar with the Wachovia decision. So seeing the rule is very helpful and creates a lot of certainty. So I don't favor having no rule. In a funny way, I almost saying like a hybrid because it's that last 20 days that seemed the most problematic, and I can see in this context that this doesn't make a whole lot of sense in the motion for review context. So I just threw that out.
Thank you. Dan?
I think I just forgot to put my hand down, for which I apologize.
Okay. All right, Jamie.
I guess I forgot to put my hand down, but I will say one thing. I don't have any, from my perspective, I would like to keep in the 20-day, the stay for the motion to reconsider, because the court will still be reconsidering, and we have on occasion reconsidered dispositions of motions for review. If the group wants to consider taking out the 20 days for a petition stay, which was in Wachovia, I personally don't have any objection to that one. And that's kind of the hybrid that I think Jeff was talking about.
All right. Dan, your hand's back up.
I don't know what to tell you. I blame technology.
Okay. Anyone else want to be heard at this point? So maybe what we should do is first take up Wes's proposal and see if there is a motion to adopt Wes's proposal. I am not hearing one. Ken, are you continuing to advocate for this, or?
Well, I can. I'm not being a regular member of the committee. It wasn't clear whether I can move a motion or not. Oh, come on.
My understanding, Jill, that's fine, right? Ken, on behalf of Jill, of Wes, you're muted, Jill, but.
Okay, I will move that the Rules Committee adopt Wes's proposal.
All right.
I'll second.
And who was that?
Charlie Ray.
Okay. Further discussion? All right, no further discussion. We'll try all those in favor, say aye, but we may have to do a more formal count. But let's try all those in favor, say aye.
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 I heard 3 or 4. All those against adopting Wes's proposal, say aye.
Aye.
Aye. All right. I think we'd be better off just taking a kind of a roll call vote. So I'm going to go just kind of in the order that they're on my screen at the moment. And if I miss somebody, please let me know. Dan Krish.
Aye.
Claire.
No.
Charlie.
Aye.
Jeff.
No.
Lauren.
I've never done this in my life, but I'm going to abstain.
Okay. Jamie.
This is on Wes's proposal?
Correct.
No.
Okay. Paul.
No.
We know Ken Barchi is a yes. Carolyn Ziogas.
No.
Okay. All right. Now the initials are going to be a little harder. Jill Begeman.
No.
Giovanna.
Aye.
Okay. Who have I missed? Charlie Ray.
Gotcha.
I can vote twice if you'd like.
Eric Levine, aye.
Okay. Colleen.
No.
Okay. And Justice Doria.
No.
And I'm a no. Have I missed anybody?
It's just the opinion, also a no.
Okay. And Kathy.
Also a no.
Okay.
Bruce, also no.
All right. So I think if my math is right, there were more no's than yeses. Anyone else keep track of them? Colleen?
I kept track of them. There were significantly more no's.
Okay. So the next would be to entertain a motion as to whether or not the proposal that had previously been given to the committee that would essentially codify the rule in TOSIC be adopted. Do I hear a motion for that?
This is Dan Krish. I will move approval of the previously suggested proposal.
Okay, is there a second?
I'll second it.
Okay. Attorney Porter is second. Further discussion?
So can I, it's Jeff?
Yeah,
Yeah.
go ahead.
So, if one is hoping that perhaps there could be a middle ground, which is to eliminate the 20 days after the reconsideration in the context of a motion for review, then I suppose one would then say no, and then it could just be tabled for further consideration, or I'm just trying to think how people view this vote as going from a procedural standpoint.
Yeah, I mean, I would defer to maybe Jamie and others in the working group about whether they think it would be necessary for it to go back to them to mess with the language if we're going to come up with this middle proposal, or whether, if it was accepted, whether we could do it on the fly today. Jamie?
I think all we would have to do to the proposal that we initially put forth was to take out the last sentence in that first paragraph. We might have to tweak the commentary a little, but you could take out, if such a timely motion for reconsideration is filed, any stay that was in effect shall continue until 20 days after its disposition, and if it is granted until the appeal, no, that's finally determined. So that's not the one that's the problem, is it? Wait a second.
No.
No.
As I understand Jeff's point.
Yeah. So if such a timely motion for reconsideration is filed, that's fine. I don't think this actual version in Proposal 7, does that include that extra 20 days? I don't see it there in this version.
Oh, that's interesting.
Because I thought it was in there. But if I'm looking at it now, any stay of proceedings that was in effect during the pendency of the motion for review shall continue unless the court having appellate jurisdiction rules otherwise until the time for filing a motion for reconsideration under 71.5 has expired. If such a timely motion for reconsideration is filed, any stay that was in effect shall continue until 20 days after its disposition, and if it is granted until the appeal is finally determined. I think there was a question about making a change perhaps in the other rule about that stay continuing beyond the 20 days. This proposal doesn't specifically say that it continues for the filing of a motion to reconsider. If you wanted to clarify it, you could take the last sentence in Wes's proposal. But even that, I don't think does it.
This is Jeff. If I can just jump in, I think the problem is the until 20 days after, just those 4 words.
Any stay of proceedings in effect on this until the time for filing the motion for reconsideration. Yeah. Any stay that was in effect shall continue until 20 days after disposition. That's the language, Jeff. You're correct.
So if
we
were to take
out
out those 4 words, it would read, if such a timely motion for reconsideration is filed, any stay that was in effect shall continue until its disposition. Meaning the disposition of the timely motion for reconsideration.
Yeah, so it's those
and of course, if it's granted, although I will say that the word appeal, I think is actually the wrong word, because this is on a motion for review. It's really until further proceedings on the motion are.
No, if you granted
not an appeal.
No, it would be the appeal, because if you put the stay back into effect, Jeff, it would stay for the appeal.
Because there is no appeal. This is a motion for review of a trial court. Isn't this a motion for review? Concerning a stay of execution, there may not even be an appeal.
Well, I think that's right. In some instances, there could be an appeal, and in some instances, there might not be.
In those instances, we often use matter until the matter is determined. So it encompasses all of them.
The matter sounds correct to me.
And that would cover both a motion for review and
And an
any,
appeal.
and in an appeal.
Yeah, I think Carolyn's correct. So if we put forth that we have the proposal as the original proposal with the change recommended with what Jeff said, that any stay that was in effect shall continue until its disposition, meaning the motion for reconsideration. And if it is granted until the matter is finally determined, is that a proposal that people could agree to with those amendments?
I think this is Paul Harton. I mean, it sounds like that would accomplish at least
Part of it.
yeah, the elimination of that 20-day stay pending the filing or the opportunity to file a petition. So I think to Jeff's point, that accomplishes that. I don't know if it goes as far as Ken would like. But I suspect you probably have an opportunity to reach some consensus with the group.
All right. Anyone else want to be heard on that? Ken?
Yeah, I mean, I think there's not support for Wes's proposal, and that's fine. I think that having clarity and eliminating the 20 days after the disposition, I think cleans up a lot of, cleans up some of the issues, and also at least truncates somewhat the length of the stay. So I think that it makes sense that's a reasonable middle ground.
Judge Prescott, this is Paul Harton. Colleen, I don't know if you caught that language. If you did, could you just read it back?
Yes. The proposal as amended by language with from Carolyn Ziogas, Carolyn Ziogas, Jeff Babin, and Jamie Porter. The final sentence of the original proposal, page 7, would read, if such a timely motion for reconsideration is filed, any stay that was in effect shall continue until its disposition, and if it is granted, until the matter is finally determined.
Okay. Jeff, does that capture what you had hoped?
Yes, thank you very much.
Okay. Jamie, is your hand up still, or?
It shouldn't be, I'm sorry.
All
Having
right.
trouble learning how to lower my hand.
Okay. Jeff, do you want to make a motion with that modification?
Sure, I move that the proposal that was on page 7 of our packet intended to codify the holding and Wachovia v. Tosic be approved with the change that the words until 20 days after be removed from that proposal.
All right. Is there a second?
I'll second it.
Okay, second by Attorney Porter. Further
Excuse me.
discussion?
Oops.
You also wanted to change the word appeal to matter, and that
Right.
wasn't.
Yes.
Yes, and I will add that to my motion, and that the word, instead of saying until the appeal is finally determined, it will say until the matter is finally determined. Thank you so much.
Okay. Is there any further discussion? All those in favor say aye.
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 Any opposed? All right. Progress.
Great. The next item is, I guess we're into new business. No, are we? Yeah.
Yes.
New business. And item E, Judge Prescott, were you going to do this one too?
Only
Or do you want to?
Only to ask Jill to speak about it.
And I think you can all agree that we divided these things up in equal gravity, complexity, and controversy. So the number of paper copies, why don't we move on to that?
So I will address that. This is 67 pages 16 and 17 of the packet. And basically, we're moving towards, we've got an experimental or optional EP program now. We're looking to reduce the number of paper copies. So both courts kind of did an inventory of the number of copies of paper briefs that we need. And we are planning to reduce at the Supreme Court from 15 to 12, and at the appellate court from 10 to 8 copies. So that's really the background, and that's what this is about.
All right. Does anyone want to be heard on this matter? So, Dan, your hand is perpetually up. Okay. So Jill, what? Well, let me ask kind of the group. Does everyone feel like this is some progress in at least cutting the number of copies, and that this is a good idea going forward?
Yes.
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 Very much.
All right. So I would think that the next step would be just to have some language drawn up for the next meeting. Is that right, Jill?
It's actually in the rule already on sub-page on page 17.
Okay.
And I think Eric, did you have your hand up?
Yeah, I was just wondering when the committee was hoping to have this rule become effective. As we are working in, the 2021 rules, I don't know if it was more of an urgency to have this rule become effective sooner rather than later, or.
We haven't talked about making it effective sooner than later, so I was figuring that it would go in the packet of rules that you're working on right now, the 2020. Yeah,
well, we're in the publishing stages for the 2021 book, so we would have to make it an interim rule if we wanted to make it sooner than 2022, which, that's a long way off, so I didn't know what the purpose of, whether we wanted this done sooner rather than later.
Is this something that, well, maybe Carolyn, you have a view on that, because if we weren't to do it, it might be something that we could be telling, in your appeal papers when you send them out, you could tell people you need fewer copies. What do you think?
Yes, I do. But Jill, wasn't this from Judge Bright's suggestion?
It was when we started storing the briefs over here. But that being said, I don't know that there was a thought that we need to have an interim rule adopted at the same time. So that I guess the committee wanted to do that. I think that's an option. But we hadn't discussed that.
And Justice Deary, on the briefing program, the electronic briefing program, they're coming in now. They already have reduced copies on that per the guidelines. So that does take care of a group of people.
I got you. Yep.
Claire.
I have a question about the electronic briefing program, because I think there are our office took a look at it and is concerned the amount of staff work needed in order to file something under that optional e-filing program. And so if there's a possibility of lowering the number of and I think we'll discuss that e-filing program later, I assume, but it's a matter of just lowering the briefs sort of overall, as opposed to just associated with the optional e-filing. That would be nice to know. And even if we do it now, and the reduction is modest that we're proposing in this rule, but if even if we pass it now and then by the time the 2022 book comes out, the e-filing program, bugs might be all sort of shaken out, and you might even reduce it further. So I guess I would say there's no problem voting for a lower number of briefs now. And if we need to modify it even lower later, then we certainly could.
Justice Doria, do you have a feeling about whether to do this on an interim basis or not?
I don't feel strong. I mean, I think I don't feel strongly about it. I feel like, I mean, that's something that if Eric thinks we don't need to do it, or if Jill or Carolyn don't think we need to do it, I think administratively we can probably, I'm thinking Paul or Carolyn could tell me differently, that we could suggest to, to the people actually with their appeals that they don't need to file as many briefs and we don't need to do the interim rule. That's just my thought.
To respond to that, Justice Dory, this is Paul Harton. I mean, I think we can manage this. Obviously, we'll talk about e-briefs towards the end of the meeting, but I mean, obviously Carolyn can jump in, but it seems to me we can manage this.
Without an interim rule.
Yes.
Yeah.
I have my hand raised.
Yeah, go ahead, Carolyn.
Oh, okay. Yes. What we could do is we send out an appeal letter, and we have a lot of information about briefs right now. We've just added to it because of the electronic briefing, also now providing with the checklist in that letter, which goes out at the very beginning. We could include that, as of this date, you only have to file this many copies, and they would get notice.
All right. Well, it seems to me we have a general consensus that we could do this. We don't need to do this as an interim rule, that it could be handled administratively for now, but that it would be effective in 2022, of course, dependent upon anything we do with e-briefing.
Charlie, did you have your hand up and then you put it down?
I did put it down. Just one quick comment. I don't really have strong feelings on when this goes into effect, the difference between 12 and 10 and 10 and 8 or whatever the numbers are. From where I sit, the big difference is between 0 and wherever we are. And the sooner that we can get to 0, the happier I'm going to be, because it takes one more headache off of my plate. And I think, not to wish this on anybody, when we first got into this mess that we're in now, there were deadlines that were not moving at all because of the lack of the ability to submit hard copies of briefs. And I had a case where I e-filed a brief, an appellee's brief, and it was 4 or 5 months before the time for the reply brief even started running because I couldn't submit my hard copies. And so I certainly don't wish that we go through this again, ever again. But if we can get the hard copy requirement down to 0, I think we're all going to be better off in the long run.
All right. Well, I appreciate those comments, and this would be certainly an interim step towards that, if that's able to happen. So, is there a motion to adopt the proposal regarding the reduction of the number of hard copies?
I'll make the motion.
And that was okay. Is there a second?
Second. Charlie Ray.
That's Charlie Ray. Any further discussion? All those in favor?
Aye.
Any opposed? All right, that's adopted.
Okay, I'll move on to letter F on the agenda under new business. And I neglected to point out at the beginning of the meeting, Allison Chandler is also on here from our external affairs office. She is streaming this meeting to our YouTube channel. She handles that for the branch and for our appellate committees. So I appreciate her doing that. I think it's a great improvement for any of the public that's interested in monitoring what the committees do. 84A2, to clarify Superior Court rules or the rules of appellate, whether the Superior Court rules or the appellate rules of procedure apply to motions filed in original judgment actions. This is a clarification. Carolyn, you're going to lead this one out?
Yes, I will. Carolyn Zayogis on page 18. The this rule change came this summer. We had reported original jurisdiction, an original Supreme Court jurisdiction matter in Fay versus Merrill. And shortly after the filing of the action, one of the parties filed a motion to dismiss. We returned it because it was clearly not in compliance with our appellate rules. The attorney called me, and together we went through this rule, and it was, I could see where, he thought that the Superior Court rules apply in this instance. So we checked with the Chief Justice, and it was the Chief's understanding that if there is a rule in the appellate rules that applies, those rules should be followed. And other than that, with the Superior Court. So the change in this rule is an attempt to make it clear for the practitioner when to follow the appellate rules of procedure and the Superior Court rules.
Okay. Anybody else want to discuss this, or are there any questions or concerns? If not, is there a motion concerning?
Yeah.
Yeah,
I'm
go ahead,
sorry.
Jeff. Sure.
I
go
just
ahead,
had, my apologies. I didn't raise my hand quickly enough. So I don't have a problem, and now I'm just going to be picky, but just with the reformulation of the words, I actually had a more of a kind of a grammatical comment, which is the new language says that the form of motions and any other documents prescribed in the rules of appellate procedure shall be filed in accordance with the rules of appellate procedure. And the words shall be filed didn't really match with the form of motions. You don't file a form of motions. And so it really is sort of, I'm thinking the form of motions shall be in accordance with the rules of appellate procedure, and I'm not sure the word filed needs to be there. Does that make sense?
Yep.
And then I think the same problem happens in the next sentence.
Why don't I, how about Jeff, if there's no other discussion, why don't you make the motion and make those changes in the motion you make? Is that okay?
Sure.
Just orally, you can do that.
Yes. So I move that the proposal.
Let me just make sure. Anybody else want to discuss this? Oh. Dan, did your hand go back up after
My hand is actually up for real this time.
You might want to limber up before these meetings, Krish, because you're going to pull out an ace.
I have a 2.5-year-old and a 4.5-year-old pulling on my limbs, so I don't know whether they're up or down. You're
going to need Tommy John surgery or something. Okay, go ahead.
It's funny, my son is actually a lefty. So I agree with Jeff's concern, but now it omits or eliminates the fact that in some respects, filing things is different for appellate motions and documents than it is for Superior Court motions and documents. So if we're going to take out filed there for grammatical reasons, which I think Jeff is right, it needs to be made clear that the filing of those motions and other documents prescribed in the rules of appellate procedure also needs to be in accordance with the rules of appellate procedure.
Okay. Eric, did you have something before that is complementary to that, or a different issue?
I just wanted to clarify. I guess it looks like there's two places where the word filed needs to come out. Is that what the proposal is?
There was a problem with the following sentence, which we haven't gotten to yet. Similar.
How about we just make it, if I may make a friendly amendment to Jeff's amendment, I don't know if that's allowed. How about the form and filing of motions and any other documents prescribed in the motion shall be in accordance with the rules of appellate procedure?
Well, I was going to say the filing in form of, but we can go with your order.
I'm unable to out-pedant that, so I just
and Jeff, so then did you have another concern about a different sentence, or does that?
Yeah, it's the following sentence. Let's see. It says, in all other respects, unless otherwise ordered in a particular case, the form of pleadings and motions shall be filed in accordance with Superior Court Rules of Procedure. So I guess you would do the same thing there, right? It would just be shall be in accordance with Superior Court Rules of Procedure. And we
Yeah,
can do the same thing. The only question is whether that also works the form and filing. Because once you say the filing shall be in accordance with the Superior Court rules, then you're only going to have, well, now that I'm thinking about it, what is it we're trying to capture when we add and filing? Because we don't file paper copies anymore. And so, I'm sorry?
Electronically filed, it's the same.
I see.
Let me well, hang on one second. Can you just hold that thought a second, Jeff? Because I know, Claire, did you have something that's a different issue, or
well,
are you wordsmithing?
it's not a wording issue. And my colleague, I'm sure, is very happy to hear that his concerns are being considered on this particular issue. But exactly, I guess, looking at this, I find myself a little bit more confused about which things in an original jurisdiction action are following the appellate rules and which matters are following Superior Court rules. I mean, the sentence is all lovely, but so if I'm having original jurisdiction action, what things am I under? They're both are talking about motions and other things. So which one goes where? And maybe it's a sort of obvious to folks who do this all the time, but I'm a little lost.
Carolyn, go ahead.
Yes, I think it was anticipated so that if, for instance, motion to dismiss or any of the motions that are set forth in our rules, and it's clear that we have a rule for it, that you would follow that. It's possible in an original jurisdiction action, you may have motions for summary judgment, you may have, other motions that we don't address at the appellate level. So I think that was the understanding, that you would then go to those rules, but, start at the appellate rules.
Okay, so to the extent there was, sort of requests to revise type thing, yes, you would go for the appellate court, you go with the Superior Court, whereas a motion to dismiss, you'd be with the appellate court.
Yes.
So, how about this? Well, Carolyn, I guess I'll ask, and Jill, could you chime in on this? If this is a wordsmithing issue, what's anyone's pleasure? Can we, when I was on this committee years ago, I don't know if we still can do this. I mean, if people have no problem with the concept, can we circulate language and approve it by email? Or is this something that you want to wordsmith and put it on for another meeting? It seems like it's not controversial. Can I ask Jill what is appropriate here before?
I think you could do really, frankly, either, because there have been occasions when the committee sent things out for vote by email with some word smithing. It can be a little clunky with 20 people chiming in to get the final version. So we don't do it that often, but it certainly can be done. I think it's really up to the coach.
Okay, how about this? And Judge Prescott, I'd be interested in your view. If we, I'm going to throw it out in a second to hear if there is any more discussion on the concept of this or the actual, policy of making the change. But maybe I could ask Jeff Babin and Dan Krish, and maybe if anybody else wanted to work with Carolyn to wordsmith it, and then we could send it around to the committee, and we could call for a vote if people were okay with that. Any concern about that from anybody? Does anybody have a problem with our bringing this to a vote? Subject to that small committee I just put together, or if somebody else wants in. Dan and Jeff, your hands are raised, but I assume we're kind of just coming back to you.
Yeah, that's fine. I'm happy to work on that.
Dan's hand went down.
I as well.
And Claire, what your hand went back down?
I would like to be on that committee, but it seems to me like you guys we had reached the language that sort of satisfied everybody. which was add filing and before the word form for both parts of it, and take out the word filed in that sentence. Was there any other sort of substantive change that you guys wanted to make as far as your wordsmithing?
Well, I think there may be some complications just because, as I think about it, right, you're going to want the appellate e-filing procedures used even if you're filing the form of the Superior Court. So Dan's idea of putting the form and filing of motions should be in accordance with the Superior Court doesn't quite work in that context. So I was going to suggest not having and filing. But then I start worrying that there are things that maybe we're not thinking of in the heat of the moment once we start getting into that level of detail.
I'm happy to work on a committee if that helps.
Judge Prescott.
Yeah, my quick thought on this is that, these don't come along very often, so there's probably not a lot of time urgency to this. I don't think we should rush to do something right this second until everyone's happy with the language. So I think an email vote after some people have really sat down and noodled it through is a good idea.
I think that's fine. I would say, yeah, as of today, it doesn't need to be done. I mean, if these things do get filed, this is the season for it. So if it's something that, otherwise it's just something Carolyn needs to manage in getting the things filed. But so I guess unless somebody has an objection, I think I'd look for a motion to however we would
table it.
Would we table it, or would we try to approve it subject to the email wordsmithing? Jill, what do you think? Or Carolyn, do you think, is this something we need soon?
Yeah, I think it would be helpful to work with this small committee. Briefly, we could do it very quickly. And that's what we come up with and present it. If it's not, we can always mark it over further.
Okay, so that means we won't vote it today. We'll follow up. We'll table it as Judge Prescott indicated. Claire, do you have something else? You want to be on the committee? Yeah. So yeah, Dan, Jeff, Claire, would you work with Carolyn? If anybody else was desperate to get in on that, that's fine. Okay, very good. Thank you for all of that. Judge Prescott, you want to talk about letter G?
Sure. So this is a proposal that I believe Carolyn Ziogas has kind of proposed or is leading out. Carolyn, do you want to kind of update or explain this?
Yes, this proposal begins on page 19, and I'm just going to give you a little background to this. We had discovered that in the Superior Court, they went to filing an application form. I don't know whether you know or not, but the clerk's office, the case managers here, review all of these and dispose of most of them. And it's, the format of them is often difficult. You're trying to find certain information here and there within history, facts, and legal grounds, and it didn't seem to make sense. So when we saw this form that the Superior Court was using, we thought, what a great idea. We could do this and work with Superior Court and legal to come up with one form. It would be easier for the practitioner. You file the same thing basically, with some small changes in one court and the other, and where those changes are is applicable on the form itself. Make it easier for the practitioner and us as well for processing without a lot of needless information that is contained. So we worked on this a lot, worked with, like I said, legal and the Superior Court to come up with one form. It still has the required affidavit, and again, set forth in a form. And then we adapted the rules so that it was in order of the form to make it easier for the user to go through step by step. And so that's what this proposal is.
Anyone have any questions for Carolyn or comments? I'm not hearing any. Someone want to make a motion?
It's Jeff Babin. I'll make the motion to approve.
Okay, is there a second?
I'll second it.
Okay, second by Attorney Kindle. Further discussion? All those in favor say aye.
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 Are there any opposed? All right, that's adopted.
Okay, I think, Paul, you were gonna discuss, somebody else?
Yep. Reply brief. H.
Reply brief?
I think.
Oh,
this
yeah,
is
I'm sorry.
Dan, Chris.
Yeah, yep, Dan.
This is page 24 is what we're talking about of the packet?
Yes.
Dan, you want to talk about that?
I don't have much to add beyond what's in my email to Jill on page 24. There's a lacuna in the rules about what you do when there's more than one appellee and they're filing separate briefs. I had this come up a couple of times. You know, the appellate clerks certainly grant motions for extension routinely when that's the case, but it seems like we could save everybody the trouble if the rule just expressly provided that the time to file your reply brief doesn't start until the final appellee's brief is filed. Looking at my wording now, I must have had a raucous Labor Day weekend because my additional language is not the best. But that's the intent of it, is so that however many appellees there is, when the last appellee's brief is filed, your 20 days starts to run. Because you only get one reply. So.
I wasn't looking, but so I'm going to go Carolyn, then Jeff.
Okay. Yes, I think this is a very good idea. We get a lot of questions in this area, but I would like to see it clarified just a little bit more. And you just say a reply brief, but one single combined or a combined reply brief, and also speak to the page limitation. That should still be the 15 pages because that will come up as well.
Okay. Jeff?
Yes, actually what was just stated by our chief clerk was what was on my mind. But that raises a question because the rule actually doesn't specify if there's more than one appellee brief, what happens with the reply brief. And I thought that I had heard in a case a couple of years ago, which actually surprised me, that the clerk's office allows a separate reply brief for each appellee brief. Maybe I'm misremembering. I hadn't even been aware of. I always thought you would just file one reply brief and you needed more pages. You can get them in that circumstance if the appellee briefs are very different from each other. But then I thought I had a case where somebody actually filed more than one reply brief. It was just a single party with one counsel, in which case it wasn't clear how this rule, as Dan has redrafted it, would apply to that situation. And so I think there's more ambiguity than even what's being addressed by Dan.
Carolyn, what do you what's your practice?
Yes, well, in the past, we have accepted. We've had instances where a reply brief will come in response, and then another appellee will get permission to file one, and it will be late, and they'll come in. So we have had multiple reply briefs. We, had the policy to have one. In those most instances, we do follow that, but this is why this rule would be very helpful for us as well to have this wording with the additional language. I think it would address all of our concerns.
Yeah, so that would be a good reason to have it in the rule. Go ahead, Dan.
I would say I certainly would welcome additional language to clarify and address any other sorts of problems that have come up in these multi-appellee or multi-appellant situations, just so that we can have real clarity on reply briefs and the timing of them when there's more than one thing to reply to or more than one person replying. So.
Carolyn?
Yes, we could work on that language as well.
So how do you want to handle it? Or Jeff, do you have something else to add?
Yeah, if I may, there was actually one other issue that potentially complicates this, which is there may be an appellee who files a brief. There may be other people technically specified as appellees who actually don't file anything at all. Even though appellee briefs are mandatory, there may be people who are, because anyone who's not an appellant is listed as an appellee, but they're really not involved and they haven't specifically written or done anything to say they're not involved. And so if you have an appellee who, say, files early, can you wait until the deadline runs, until the other, until your time to file starts? It's a little unclear what happens when he says until all the appellees have filed their briefs, and maybe there won't be some additional briefs. Maybe nobody knows if there's going to be a second brief or a third brief.
Yeah.
And somebody's filed, and normally your time begins to run.
I think practically that doesn't happen very often, Jeff, because most of the parties know the parties that remain that have an interest. So it has happened, I will say, but it really doesn't happen that often.
Okay.
Okay, so Dan, this is your proposal. You've heard a couple of, I guess maybe wordsmithing or some ideas for improvement. Do you want to try everybody's mind and put a motion out there?
I guess I would prefer to try to encompass everybody's concerns into a better drafted proposal. Okay. I don't think this is urgent, so I'll try to take everybody's thoughts into account and submit a revised proposal that we could put on the agenda for the next meeting, if that's okay.
Fine. Yep. Carolyn, you still have your hand up, or?
No, should be down. Sorry.
Okay. Anything else to add to that?
No, that's good. That's fine.
All right. Unless anybody else wants to be heard on that, I guess we'll pass that and wait for the next meeting on that. And I think now we'll hear from Paul on an update about e-briefs.
So just to update you all, obviously, this is a work in progress. You know about the optional program currently have in place. So Jill and I have discussed this with the co-chairs, spoken with the Chief Justice as well. And so the idea here is to try to get e-brief rules drafted for the spring meeting. The hope is to get them on for the public hearing and to get the courts to approve rules before they recess in the summer. And then obviously some of the details about an implementation date. We still have to talk a little bit and figure out about, dual filings, if there needs to be a period of dual filings for paper and e-briefs as we transition. To Charlie's point, I think a lot of folks would like to move to zero paper briefs. I think some folks would like e-briefs to go away and keep paper forever. So we got to kind of try to find the balance and try as we move forward. We've had some discussions about absorbing the work of the e-briefs transition and development committee into appellate rules. It may be. We certainly don't want to duplicate efforts. So I've spoken to the Chief Justice about that. That we'll continue to pursue that. And as you may know, that committee was established, I think, in 2018. We met in January of 2019 and haven't met since. There's been subcommittee work, but that's sort of the direction we're trying to go. Obviously, as we work through these rules, certainly reaching out to the private practitioners in this committee for input. And you're certainly, anybody who's interested is welcome to work with the appellate rules work group, and we would encourage, hopefully some of you would be willing to participate in that as we try to draft these rules, and really hope to get to full e-briefs next year. Carolyn can certainly talk a little bit more. We have been getting some optional briefs through the program, optional e-briefs. And I think just the story, and I think Judge Prescott has seen at least some of what's been filed. So we're certainly encouraged based on the functionality of these briefs. So this was just to give you sort of an idea of what we have in mind or what we've been talking about. And obviously, I'll turn it over to the co-chairs as far as any further discussion, but that was kind of to bring you into the fold as to at least what's been discussed administratively with the Chief Justice and others.
Yeah, well, I don't have that much to add right now. The bar and the the practitioners would be. It wouldn't surprise me if folks are impatient about this. The work, the spade work that needs to be done is on our end, technologically certainly, but also kind of just to bring religion to people here. We're not talking about something that's. We're talking about something that's basically the whole job. Is reading the briefs and how people get their work done. So it won't surprise, I think, a lot of you who are in firms who that people have strong views about how they get their work done, and so it went from being it being sort of working through a lot of situations where people had different views to all of a sudden e-briefs became a huge need because we were all in our houses without access to paper. And so that's working together has been harder to do remotely. So I think we're on a path to getting the courts to a position where this is going to be the future, and people will understand that it's the future, and hopefully we'll be in a position to start drafting some rules, and we'll be eager for your cooperation and input in that in the months ahead. Claire?
A couple of comments on this. First of all, our office is extremely happy at the idea of e-filing and e-briefing. And I would think one of the interim steps this committee may want to consider is timing that when there is an e-filing for the brief, saying that's the date, that's the moment that the brief has been filed, and that when the paper copies show up, they show up later. That's fine. Right now, I think it's the reverse. That is, you e-file your brief on timely, but your filing isn't accepted by the clerk's office until the paper copies are received. But I also think if this is an appropriate place to give a little bit of feedback on the optional pilot program. Is there a reason why we're numbering all of the paragraphs? Because that causes all kinds of trouble with our word processing system. And if you do any edits at all, suddenly having every single paragraph numbered, is there a purpose for having every single paragraph numbered? I can understand the sort of the headings and the subheadings and the spacing and all of that, but having every single paragraph numbered actually does terrible things to the format and is making things very difficult for purposes of our word processing. It's the first question, and then I got a couple of other quick points, but that's the biggest issue.
I could speak to that. Claire, that happens to be one of the ways for better navigation for the judges and the participants with it a lot to find it. But the feedback, this may be something that the judge and justices decide, okay, this may not be necessary, but we try to implement as many of the recommendations as possible, and then to get your feedback and say, wait a minute, this is too workable, and then present it to the judge. If you can, send us us something in writing, I can present it and talk about it and say maybe we take that as guidelines, or have the brief filed and then, with your certification indicate where the guidelines haven't been followed, in order again to help us really make the best possible one we can.
Carolyn, we are way too intimidated by you to send something in and say we only followed part of the rules and not the other part of the rules. That's just not going to happen.
Oh dear.
We're going to follow all the rules. So if you tell me how to give you feedback, we'll happily do it. But we're not going to say we only picked and chose which rules we liked.
Okay. All right. So continue to file it as such. Then send me something in. I have a folder. We're going to go through everything when we, address all of the concerns again. And we're working with things constantly. I mean, this has actually been kind of fun. I know I don't have a lot going on in my life right now, but getting this brief and picking it apart and looking at it and seeing, one that's filed. We have one in the Supreme Court for the first time that looks really good. And we hopefully the other side will file it as well. And I'm hoping by the spring to have this before, the Supreme Court too. And we have a few in the appellate court. We have some self-represented parties who've done a really good job. So, it's exciting. And we're willing to work with you.
A couple of the fonts, and we were very happy that you changed things in the beginning of October, because we didn't own those fonts and couldn't afford those fonts. Okay. That the fonts just are not part of the usual package for Microsoft Word, and were not available. And talking to our IT folks, or they kind of went into panic at the thought that they were going to have to get them. The other thing was a hyperlink to the appendix sites. I had our paralegals kind of want to go on strike and say, okay, you need to tell all of your lawyers that they have to have final documents to us so we can advance. And that would be, and I don't know about anybody else's in private practice, but telling anybody in our office that their brief had to be absolutely final a week in advance is not going to happen. But I also think that how we do appendices and how they're used really needs to change. I think that appendices filled with people's briefs is ridiculous. That if somebody wants to read the briefs below, they can link to the briefs below. And it would be interesting to me to know from the judicial branch's perspective what is most effective in an appendix for the people who make the decisions, and sort of limit it to things such as the decision below, any trial transcripts that are necessary, some key documents, as opposed to, at least my experience has been that we set, cases, particularly if they have a long road to the appellate court, tend to have very large appendices that probably could be like half the size.
Right. I don't.
But that's perhaps a different discussion, but it comes up in the context of you want to have appendix sites hyperlinked. And that is, I think, perfect and very appropriate for purposes of making the full use of an e-filing. But boy, it's going to substantially add to the time needed by support staff to get anything ready for filing. So that's the feedback I have thus far from we pulled together a little internal subcommittee on the e-filing options, and they want to make sure I express those thoughts at this meeting.
Okay, thank you. We are proceeding with baby steps, and I don't know if I dare say this or not, but in some states, I'm not going to say it's going to happen here, they've actually gone to the elimination of the appendix because they're able to pull in things from the trial court files. So we're a little bit away from that, even bringing that up, I think, at this point, but it's something in the future that can be looked at for sure. And I will say this, we have been working with people who have filed the electronically, and we try to do, a review within 24 hours. We get that because we know, the deadline is coming up, and it is good cause for an extension of time. If you're participating in this and you need a couple days to get the, paper brief in because you're trying to perfect the electronic version, that is certainly good cause to get you that extension of time. And we have been, doing that, and we've had good success with that.
Thank you.
I think there'll be, I hope there will be in short order, an opportunity to get more feedback from folks who are participating in this optional program, and to give our own feedback from the court's perspective. I think it's a little late today to maybe start that conversation, but I think Paul's name just to let you know that this is something that this committee is going to have on its plate, hopefully in the spring, and that as we round the corner into the new year, there's going to be different opportunities and need to discuss these issues. So it's probably a little bit early to have continued comprehensive feedback on this from either back and forth from the court or from the practitioners, but I think that's why we're bringing it up now. Paul, anything to add on that?
Yeah, just real briefly, because I know it's been a long meeting. So from my view, so I know you usually get these packets of proposals, in advance of these meetings. We're going to certainly try to, obviously this is a bigger project. We're going to try to get this out to everybody, early on, get your feedback. Obviously, for those of you involved, you'll be participating, but the idea is we may just try to continuously provide information as we get the final drafts and then get some feedback from all of you. I think on the internal hyperlinks, we can have that conversation another day, but that's obviously we need to hear from all of you how burdensome these things are. It's critical for us, because I think for the court, from our view, for the way that the court does its business, hyperlinks are a big part of this project. So we'd like to hear from all of you as you move through this process.
Okay. Judge Prescott, anything else on? You're muted.
No, unless there's any other business that anyone wants to raise before the committee.
I guess we can entertain a motion to adjourn if we need one.
So moved.
And a second. I'm sure there's many seconds, and all those in favor.
Aye.
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 Okay, thanks everyone. Appreciate it.
Thank you.
Thank you.
Thank you.
care.
Thank you.
Bye.
Bye now.
Soon.
Stay well, everyone.